Did your check bounce or did you receive one that did? The moment that check was returned by the bank, a legal clock begins. Not when you decide to act, not when you call your lawyer, but the moment that check was returned by the bank. And the difference between winning and losing usually comes down to one mistake: thinking that this is about the check, while it's not. A check bounce case is built or challenged on what happens around the check. The dates you act on, the notice you send, the evidence you have or haven't gathered, and the strategy you choose from day one. Get those right and the law is on your side, but get them wrong and even a completely genuine claim will not survive in court. So let's talk about that clock. Under Section 138 of the Negotiable Instruments Act, once a check is dishonored, three deadlines start running, what we refer to as the 30-15-30-day rule. Number one, you have 30 days from the date of receiving the return memo from your bank to send a written legal demand notice. Number two, the other side then gets 15 days to make that payment. Number three, if they don't pay within those 15 days, your complaint must be filed within 1 month after the expiry of those 15 days. These aren't just guidelines, these are strict legal deadlines. Miss them by even a single day and you may lose your case before it even begins. Now, if you are on the receiving end of a check bounce case, do not make the mistake of assuming that you have no option but to pay. The law does create a presumption that the check was issued towards a legally enforceable debt or liability. However, that presumption can be rebutted and in the right case, it can be successfully challenged. Ask yourself, was the check actually issued towards a debt or liability that was actually due and payable? Or was it handed over as a security check for a transaction that never materialized? And was the statutory demand notice issued within the prescribed period and served in accordance with law? Or is there a dispute regarding the execution of the check? These aren't technical loopholes. These are recognized legal defenses that the courts routinely examine under Section 138. The key, however, is timing. A valid defense is only as effective as the evidence supporting it and the manner in which it is raised. If you have received a legal demand notice, the worst thing that you can do is ignore it. The sooner you assess your legal position, preserve the relevant evidence, and formulate a response, the stronger your defense will be. And if someone bounced a check on you and you want your money back, hear this carefully. Filing a complaint under the NI Act and recovering your money are not the same thing. The criminal route does carry the threat of prosecution and imprisonment, and the court can even direct the drawer to pay an interim compensation of up to 20% of the check amount, even when the case is still ongoing. But that's not your only remedy. There is also a powerful civil remedy available specifically for such claims, where the other side cannot simply appear in court and deny the debt. Before they can even represent themselves, they need permission from the court. And if that permission is refused, you are entitled to a decree and you can enforce the debt. And if a company bounced your check, in that case, the stakes become significantly higher. And in the right case, insolvency proceedings can be initiated against the company. And at that point, the dispute is no longer about just recovering the debt. It becomes the matter that can affect the company's very ability to continue business as usual. Each remedy serves a different purpose. Each creates a different level of commercial and legal pressure. The goal is simply not just to litigate, the goal is to recover. And before we conclude, there is one recent development that every check holder and every check issuer needs to know. The Supreme Court of India has sent a clear message that check bounce litigation can no longer be allowed to drag on endlessly. In a recent judgment in Sanjabit Tari versus Kishore S. Borkar, the Supreme Court has taken note of the enormous backlog of check bounce cases pending across the country and introduced measures aimed at making the process faster, more efficient, and more effective. Among other guidelines, service of legal notices through electronic modes like email and WhatsApp have been recognized, standardized formats and streamlined procedures have been introduced, early settlement mechanisms have been encouraged, and courts have been directed to ensure these matters are dealt with expeditiously. Why does that matter? Because for years, delay was often used as a strategy, but now that landscape is changing. Whether you are seeking recovery or defending a check bounce claim, speed, preparation, and timely action matter more than ever. The decision you take in the first few days will define everything that follows. So do not wait and don't act without advice, because a bounce check is not the end of the story. Understand your options, protect your position, and enforce your rights, because your rights do not end here.